Delhi and Bangalore.
Right. Good evening, friends. And amongst us, we have Hiroo Advani, a senior partner in Bharucha and Partners, who is otherwise an authority of international and domestic arbitration law. Therefore, whenever we think of any topic in respect of arbitration, one name which immediately registers in our mind is Mr. Hiroo Advani. And whenever we have discussed with him, he comes off topics which are a niche. That today's session is also third-party funding of arbitration and litigation globally with emphasis in India. Now, as a lawyer or a professional, one thing will also come into mind, whether such third-party fundings in arbitration or other litigations also can be called upon. What are the compass within which a professional or any person, actually, or a party, can look upon that, is what we look upon in this compass of today's discussion, wherein Mr. Hiroo Advani will take us through. And he has been gracious enough to also share his thoughts eventually, even in Hindi. And thank you, sir, for accepting our invite. We look always forward to you, and that's why your sessions also do so well. Over to you, sir.
Thank you, Vikas. A little more background. I started my own arbitration law firm many years ago, and I have been ranked in Chambers, which is probably one of the best known international directories in Band 1 for India for a large number of years. I've also had the honor of being a member of the Singapore International Arbitration Center Court. And for some of you, you may be asking, what does the Singapore International Arbitration Court do? We are really only an administrative authority for the appointment of arbitrators, making the rules, deciding any conflicts, issues, etc. I am no longer a part of the Singapore International Arbitration Court, but I am presently a member of the Dubai International Arbitration Court, which coincidentally with Delhi is also called DIAC. That was just a little background on myself personally. We've now joined hands with Bharucha and Partners, me and my team, for the last several months, and it's been a very exciting journey working with Bharucha and Partners also. Now, coming down straight away to what is third-party funding? Over the years, there are many large funders globally, not so much in India, who fund third-party arbitration or litigation, largely arbitrations. Basically, it started off with smaller companies or individuals who could not afford the costs of the arbitration because international arbitration can be very expensive. So the smaller companies or individuals who could not fund it would go to a third-party funder, and the third-party funder would put up all the money, including all the lawyers' costs, if any experts are needed, the arbitration costs, the costs of the arbitration institutions, and take a share of the profits. The share of the profits can vary quite a lot, between 25 to 45% normally. And normally, as a matter of principle, everybody keeps it below 50% of the recoveries. Now, the third-party funder does an intense study of the arbitration, looks at the individuals involved, looks at the law firms involved and their capability, and most important all, looks into who the other side is, who are the respondents or defendants, because that's whom they have to recover the money from. So the party on the other side has to be big, fairly rich, well off, and in a jurisdiction which enforcement is relatively easy. Because although the party arbitration may be based in London or in Paris or in Geneva, etc., where are you going to enforce the award? If the enforcement of the award is in a country which is very litigious or very difficult to enforce, it becomes more and more difficult. So they will prefer to choose it if the country it has to be enforced is something like Germany or Switzerland, etc., where enforcement is easier and it's very fast and so they recover the money within a reasonable period of time and get a good return on the investment they made, because they made an investment into the lawyer's costs, into the arbitrator's costs, expert costs, the venue costs, any travel costs, etc., which in international arbitrations can be quite expensive, and $1 million or $2 million is not unusual for costs to be granted and the cost to be incurred. So this now, more and more countries have recognized it, and countries like Singapore, Hong Kong, London, ICC rules, LCIA, all recognize it and have got special rules for third-party funders. The rules include in different jurisdictions like Singapore, you have to disclose you have got third-party funding and who the funder is, and if necessary, the terms of the funding, because I'll come to the relevance of the disclosure a little bit later, but the disclosure rules are being more and more common and now are very strictly enforced. In India, there was a judgment in the Supreme Court of BCI, that's Bar Council of India, versus Balaji, which recognized third-party litigation funding in India and said it's legitimate and allowable. That is also a little different from what a number of US law firms do, what they call contingency litigation, which means the law firm bears all the costs and takes a chunk of the winnings. That is a completely different game from third-party litigation funding. These third-party litigation funders are exclusively litigation funding. That is the only job they do, and they are specialists in the funding. So third-party litigation funding, at least in Europe, has gone more and more popular, and it is very much a growing thing. In India, unfortunately, although, like I said, BCI versus Balaji permitted third-party funding, the problem is there are no rules. Neither the government of India has set any rules, nor any of the institutions in India, the prominent institutions like the Nalini Palkhiwala Arbitration Center, or the MCIA, or the Delhi International Arbitration Center. None of these places have rules about third-party funding, but it's, like I said, the Supreme Court said it's permissible. Why do we need rules? Particularly regarding disclosure, because there may be a conflict of interest. Some of the arbitrators may be doing work with the same third-party funder, or if they're large law firms, their law firms may be doing with a third-party funder, and they obviously will have a conflict of interest because there's a financial linkage somewhere or the other. That is why a number of countries insist on, if you're doing third-party funding, you have to disclose it. The other reason is, more and more the tendency is that in a third-party funding, if the party that is third-party funded loses the matter, then who will pay the costs? If the other side wins, who will pay the costs of it? So if you are third-party funded, more and more country rules insist that the other side can always ask for security for costs. And if they order security for costs, normally the arrangement is the third-party funder will put up security for costs. So in case they lose the arbitration, the other side is also, in a way, can recover their costs. So there are issues of conflict of interest, there are issues of recovery of costs, and there are also issues of how much is the third-party funder going to recover in terms of money. Like I said, most rules will not permit more than 50% recovery. Now, the bigger question is, why is it not popular in India, where there are a number of litigants who find arbitration and litigation, etc., very, very expensive? We know counsels and senior counsels and law firms charge quite high fees for arbitrations and then in courts. But third-party funders globally are not interested in looking at India because the courts are so slow. The Arbitration Act has been speeded up in India. There have been, ever since the 1996 Act, there have been amendments in 2015, 2018 to speed up the process of arbitration. And that seems to be working quite well, so that arbitrations are finished in a year, year and a half, 2 years. And if it goes on longer than a particular time, under Section 29A, you've got to go to the court, ask for extensions of time. And the courts can be quite particular and ask you how the arbitration processing, show us that it is progressing well, then we'll give you the extension. So you've got to satisfy the court that the arbitration is progressing smoothly as per time schedules, the witnesses are being available, and the progress is being made, then the courts will extend time. But what happens when you get an award? In India, the practice almost uniformly now is to challenge the award in a court of law under Section 34. And depending on state to state, although they've got the Commercial Courts Act, as you know, the Commercial Courts Act was amended, and any claim over 3 lakhs rupees goes to a commercial court. So the commercial courts are also overburdened, particularly in the larger cities like Bombay, Delhi, Bangalore, Hyderabad, Chennai. They're completely overburdened. And therefore, they take a very, very long time to decide the case. Having taken several years, and like I said, each state has its own limitations. We don't know whether it's going to take 2 years, 3 years, 4 years, 5 years for the Section 34 to be determined. Then you have the concept of going an appeal under Section 37, and that can again take another anywhere 3 to 5 years, 7 years, 8 years, depending how hard you press. So the third-party funders are not interested in looking in India because you don't see an end. Maybe 8-10 years is a very, very long time. Although the Arbitration Act has been amended, Section 36, so that if you succeed in the arbitration, you can call upon the other side. There's no more an automatic stay. The 2005 was amended the Act, and you have to deposit the money in court. Okay, the money is secured, but then if you want to withdraw that money, you have to give a bank guarantee or some kind of security to anyone. And that complicates the process because very often the courts in India will say it has to be a nationalized bank that can give the bank guarantees. And as a third-party funder situated overseas, then he'll have to give it to a foreign bank, then who will then give a guarantee to the nationalized bank. The nationalized bank will then give it, and then he can remove his share of the winnings. So it's a complicated process, but the main thing is the time elements. We all know how long our courts take for arbitrations, so you're unable to put any time frame as to when you'll get the money back. So all the investors in the third-party fund discourage any activity in India. None of the major international funders have office in India. Yes, it is true there are 1 or 2 smaller funders in India that have started Indian funds and do fund third-party litigation, but they are relatively small and not very well-known or widespread. So therefore, the whole concept is not spreading in India like it does in other countries and other jurisdictions. Other jurisdictions, because of the rules and restrictions of what you can do and what you can't do, third-party funding is very well organized, and the third-party funders do very well there. They make a lot of money and, so to speak, are laughing all the way to the bank. The bigger funders are worth billions of dollars. They have offices all over the globe. And what they also do with the bigger law firms who are specialists in, or who have specialists in arbitration and international arbitration, they give them a chunk of money. They say, okay, we are reserving for you $200 million or $400 million, depending on the size. You choose the claim. You find the right claim. You find if a party wants funding. So what has happened from the start of the funding, when they said they went to impoverished litigants who didn't have money to do funding litigation, now the largest companies in the world use third-party funding because they don't want to carry litigation risk in their books of account. Very large. So at least 25 or 30% of their litigation, they would prefer to use third-party funding rather than put it on their balance sheets and they can carry on safely. They are happy. The third party funder is happy. And of course, the law firms are very happy because they don't have to chase for their fees or anything. They all get well paid, paid on time as per either your timesheets or whatever you have agreed with the party. So that's the thing. The third party funders are always worried about security for costs because once you declare you're a third party funder, the arbitrators are normally very inclined to grant security for costs. So they insist that, in fact, the party, the litigant who wants the third party funding, takes out some form of insurance for that. Because they don't want to be saddled with the costs at the end of the day, because that's another risk they don't want to carry. So they insist on insurance, and these cost orders can be subject to insurance and are very often insured. And because in the international arbitrations, and also fortunately in India also, they've started now ordering actual costs incurred. Like the courts don't. The courts order nominal costs, but arbitrators are happy to look at the entire thing and order full costs to be paid, which, like I said, sometimes can run into crores of rupees or millions of dollars. And so that even the losing party, if it is the respondent party, if he succeeds, is also covered for costs. There's an interesting recent case in England against SR. SR had not paid some of the subcontractor, and the subcontractor then went for third-party funding. The third-party funding, the claimant succeeded in their arguments. They won it, and in the question of when they were granting costs, they said, well, look, 30% of whatever we won has to be paid to our third-party funder. So the arbitrators granted even what is being payable to the funder as costs. They said, whatever the actual costs incurred, plus the bonus that being paid to the third-party funder, those will also be included in costs. And that judgment has been upheld by a single judge and a division bench in England. It's presently under enforcement in India. It hasn't been decided by any the High Court whether those kind of costs, including the third-party funders' costs, can be recoverable. That is awaiting a decision in the Bombay High Court. And hopefully there will be a positive one. I'm not sure what it will be, but that's how. So this SR judgment is playing a major role in the world. It is also another reason why you're required to declare if you have a third-party funder or not, so that if whatever you pay the third-party funder from the winnings or you're due to pay them, that is also recoverable as a part of your costs claim. So basically that's what third-party funding in India and globally is all about. It's permissible in India, but not really caught on. Hopefully in the future, if our courts, Supreme Court keeps talking about speeding up the entire process in the courts. So far they are focused, I think rightly so, on criminal cases where they said now the high courts can add on judges so that criminal cases are not delayed. They're not yet focused their attention on commercial cases, particularly arbitrations which are challenged in the court, or speeding them up. The government was very conscious. They set up the Commercial Courts Act, hoping for a speedy process. But I think for a number of us who practice in the courts and recognize that Commercial Courts Act has not worked out the way the government wants, and we hope that over a period of time they'll tweak the Commercial Courts Act and give it some importance so that the whole process of arbitration can be done in a fixed time. Ladies and gentlemen, thank you for your patience. This is the overall picture of third-party funding. It's a growing thing internationally. Hopefully we'll soon see it in India, and it will grow in India just the way as it has grown in other cases. Thank you very much, everybody.
Thank you, sir.
I'm not sure we are positioned to ask questions, but if there are any questions and you convey to Vikas, I'm happy to answer them.
Yeah. So one of the questions as a professional also would like to understand. They say that, let's assume it's an MSCT case or a land acquisition matters. There they say that isn't it akin to what we say? You have that whatever you get the amount of compensation awarded, wherein the certain lawyers, we have seen that they are called as black sheep in the profession, wherein they say that they will charge 10%, but you don't pay us right now the fees. So what is the situation? Will he be in a difficulty? Let's assume he says that I will arrange the third party funding. What can be done in that position?
That is, if the lawyers are doing it and saying themselves, I will take 10% or 15%, that is what is called contingency litigation.
Yes.
As different from a third party who has nothing to do with the litigation, says, I'm putting up the cash. Here the lawyers are saying, we'll give our time and all, etc. fee. Don't pay me a fee now, but at the end of the litigation, I'll take a little bit of a bonus fee. That is contingency. That is contingency litigation and not third party funding. There are two completely different aspects to it.
Yes, sir. Because that was the question my office wanted to ask. What will be the situation? So, like we have discussed all this in English, if you could just give a brief overview in Hindi also for the audience, it would be
because my Hindi not so fluent, so I'll request you to give that.
No, they say that the best person who is the author or the conceiver, he can do. It's fine. Thank you, sir, for sharing your knowledge every time. We look forward for more sessions from your side. Thank you, everyone. Stay safe.
Thank you, Vikas. Thank you for inviting me. And thank you for the audience for listening so patiently. Like I said, if you do have questions, please send emails to Vikas, who can forward it to me. I'll be happy to answer the questions on email. Thank you very much.
Thank you, sir. Thank you.
Thank you.